My name is Yuri Eliezer. I'm the head of the Intellectual Property Practice Group at Founders Legal. In today's segment, we're going to discuss inventorship, assignment, and ownership of intellectual property rights. And we'll also briefly mention scenarios involving the hostile inventor. Now, please note, nothing in this segment should be construed as legal advice. The intended audience for this video is in-house and general corporate counsel, business owners and entrepreneurs, as well as inventors themselves. Who is an inventor? I define inventorship as those who help conceive an aspect of the claimed subject matter in a patent application. Conception is key. Conception in particular to the substantive and novel and inventive parts of an invention. Now that contribution has to provide some technical advantage towards the utility of an invention in a utility patent application. Each inventor must submit a declaration indicating that they believe they are the true inventors. Now, what is the test of determining if an inventor contributed to the conception of the invention? I like to use a two-part test. In this first part, we ask, can this inventor tell one of ordinary skill in the field of their invention how the invention would work and how it would be used in enough detail that one of ordinary skill in this field will be able to understand how to make and use that invention or that particular contribution towards the greater invention. The second part of the test, we're going to ask, was this contribution towards a substantive aspect of the invention that adds the technical advantage over the prior art or the state of the art? And is this something that we intend as the applicant to claim to be a part of the invention? Now, what do I mean by that? If one inventor did indeed contribute a very important aspect of the invention, let's say the location of a button placement on a widget. And that button's placement is key to providing a technical advantage over the prior art, and we're intending to claim that button's location as part of the invention, then yes, that inventor who conceived of that button placement location is to be considered an inventor. However, if the location of the button is not really relevant, it's not important to the aspect of the invention, it doesn't change anything or provide any technical advantage, then it may be safe to say we're going to leave that aspect out because it is not part of the claimed invention. It's also important to consider that as patent prosecution moves forward, the process between the applicant and the examiner negotiating, let's say, the scope of claimed subject matter that may be granted as a patent, the inventorship may change. Now, as you add more aspects of your invention into the claims, you may be required to add inventors who are not previously listed. Alternatively, as you remove aspects from the claims for whatever reason, you change and alter the scope of your claims, then you may be allowed to remove inventors. Now, specifics are always important, so please do not construe this as a blanket rule. Now you'll note, in the definition of inventorship, we said that an inventor is one who contributes to the conception of the invention. We did not say it is one who contributes to the execution or realization of the invention. We refer that in the patent practice as reduction to practice. So, those who merely execute a specification provided by inventors and realize that, let's say developers who build out the app that inventors conceived, generally speaking, those developers may not be considered inventors because they merely contributed to the execution or realization of the invention. So there's a two-part test to determine if those executors in the process of fulfilling the specification provided by the inventors became inventors themselves. In the first part, we ask, who provided the solution to the problem? Was the specification provided to those developers and engineers Did it specify here's the problem and here's the solution and here's how we'd like to get it done? And then moving forward, those engineers merely executed upon that? Or did those engineers have to invent and solve the problem themselves? In other words, the specification provided to them merely said, here's the problem we're trying to solve, here's, the general idea, go. And if they were indeed problem solvers, then those engineers and developers may very well be considered to be inventors. The next aspect of the question I would ask is, was there any undue experimentation required on the part of the developers and engineers? And if you provided them, let's say the inventors provide them with a specification, here's how we get it done, and the developers were able to execute and it resulted in the realized invention as specified, then perhaps inventors are the inventors and the developers remain executors, non-inventors. But if during that process they had to do some trial and error and experimented with some modules of code or inventive joints as part of a mechanical invention, then those aspects may be considered as distinct and separate inventions to which those engineers may have a separate claim of inventorship. So it's a very case-specific question. What if you hire engineers and developers? Will they be considered inventors? And how do you determine that answer? So as we've seen in the prior examples, yes, sometimes the developers and engineers can be considered inventors. Now, in this scenario, it's important to consider that we want to make sure whatever those developers and engineers contribute to our invention, we as those who hire those developers and engineers, we retain the rights to their inventions. And that they transfer their rights over to us, and we may file patents on their contributions, and that they will be willing to execute all the necessary documentation, assignment documentation, and inventorship declarations that we may need to file a patent application for that invention. This is something that should be agreed to up front. Before you know whether they will be inventors or they might not be inventors, that doesn't matter. Make sure your contracts with them have solid non-disclosure and intellectual property rights, contractual clauses that are signed before the project begins. There's another important note: proper licensing. If those developers and engineers wish to reuse some of the things they may have invented during the course of working with you, they might want to retain rights to reuse it for future projects. That is something you must carefully negotiate. Similarly, you want to ensure that any prior work those developers and engineers have used and developed for perhaps other clients or themselves, that they give you free and clear title or license to use those contributions as part of your invention. And if they happen to have violated the patent rights of others in the provision of that software or technology to you, that they will indemnify and defend you in the event of any intellectual property dispute that you might face. Two very important provisions. So, as the applicant or the business owner or the general counsel, you want to make sure that you have solid non-disclosure and intellectual property rights agreements or clauses in your contracts with these parties, and the proper licenses are built into those agreements. It's important at this stage you do contact IP professionals to help you navigate these very case-specific questions. Why is inventorship important? The United States operates on an inventor-centric patent system. Our patent system is based on the following two principles and many others, but the two as relevant to our discussion today are: first, we are a first to invent patent system, meaning the first inventors to invent something are the ones entitled to the rights. And the second principle is we are based on the first inventor to file a patent application on those rights. So the first true inventors to invent and the first true inventors to invent and having filed patent application on those rights are going to be the ones entitled to the patent rights. It is illegal and unlawful to conceal or misrepresent inventorship on a patent application, and doing so would risk the invalidity and a complete loss of your patent rights, potentially. And worse, you might end up sharing your rights with those you didn't expect to share your patent rights with. Now, patent rights are based on excluding others from making or selling the patented invention, and you might lose those rights had you not properly disclosed all the inventors up front. The default rule is that inventors own 100% of the patent rights. This means that outside of any separate agreement that attaches to the patent, like an assignment agreement or an employment agreement or a contractor agreement, inventors own all of the rights. Not the applicant, not the company who commissioned the work. The default rule, again, I emphasize, is that the inventors own the rights. This is why it's very important to make sure that you address the inventorship issue completely. Each inventor has complete rights to the invention. So if there is more than one inventor listed on a patent application and there's no assignee or owner of that patent application, each inventor has the complete rights and can do with the invention as they please. And you don't want to be in a position where you thought you had all the rights, but then you didn't transfer them to your company, or there's an inventor that emerged from the woodwork and proclaims that they too are an inventor and that you failed to list them as an inventor on a patent application. That could get messy. So, how to handle the question of inventorship? Address the issue up front. Assign the rights to the patent application before you file, even before you file a provisional application. Make sure with every contractor or employee or business partner or co-founder that you bring on that the question of intellectual property rights are addressed and that those intellectual property rights are the property as agreed upon by the inventors, who may not be inventors at the time, but at a future date will agree that if they do become inventors, will transfer the rights to the company. And this brings out a dichotomy. There are two concepts in patent law: the inventors and the assignee, those who own the rights to the patent application. Like by default, the inventors own the rights, and once the inventors transfer their rights, the entity or person who receives those rights is known as the assignee. Now there's a third concept here, and introduced in 2012, the US recognized the concept of an applicant. An applicant may be an entity that applies for the patent on behalf of inventors, and that represents that the entity has an interested or vested interest in those patent rights. Perhaps the rights have not yet been transferred, or they will be transferred, have been transferred. And there's a lot of, this is the topic of another video segment. Let's put it that way. So why is inventorship important to get right if inventors ultimately transfer their rights to the company? Our system is an inventor-centric system. All the rights stem from the inventor's conception. And if you are missing an inventor, later on, that could come back and invalidate your rights. So you got to get it right up front. The second aspect is attribution. Patent applications and granted patents are often referred to by the last name of the first listed inventor. It is a claim to fame, and it's something that's very important to recognize, and perhaps it has this sentimental value once they've transferred the rights to the entity, but nevertheless, they are listed as an inventor, and it is required that you have a full and complete listing of inventors. So let's present the scenario now of the hostile inventor. This happens when you have an inventor who refuses to sign over any rights to the entity. Now, this is a very sensitive situation, and you must contact a patent professional to get this resolved. There has been a series of rules and laws passed to help the entities, applicants, the companies, corporations, so to speak, deal with hostile inventor scenarios. But could very well be that hostile inventors refuse to transfer their rights and are required to be listed as inventors. And and concurrently can have the rights alongside the company if this situation is not handled properly. One important note is that before you file any patent application, before you file even a provisional patent application, ensure that all the listed inventors have transferred their rights in an executed assignment document. If you plan to go international, it is good to get that executed assignment document witnessed, notarized, and in ink, because some countries still do not recognize electronic signatures. And if you've got that electronic signed assignment document, today that might be good, but later on you might face a disgruntled inventor who might become a hostile inventor, refusing to electronic or otherwise sign any future paperwork. So make sure you get all the signatures done up front before you file a patent. Be inclusive when you consider who inventors are, if those inventors are under the obligation of assignment. If an inventor believes they are an inventor, you should consider that in their favor, especially if they have to transfer their rights to your entity anyway. What might happen is if you leave them off and later on there's a dispute or an issue with this particular person, they might come back and try to make a claim suggesting that they were left off. And at that point, they might not be under an obligation of assignment that they are willing to fulfill. So while things are good and folks believe that they contributed to the invention, go ahead and list them, have them sign the rights over to the company, and ultimately, if you do not claim the subject matter that they contributed, you may not list them or remove them as an inventor. Now again, everything is case specific and you should not construe this as legal advice, but some pointers I'd like to leave you with. Consider that partnership and operating agreements with your co-founders should list intellectual property rights and their disposition of those rights. What happens when the entity gets dissolved? What are the rules to compete if you leave the partnership? Intellectual property rights is central to those questions. Consider that contractor agreements, before you commission the work, before it begins, needs to address the intellectual property rights questions. And all rights should be assigned and transferred to the company or under the obligation of assignment and transfer if the invention has not yet occurred. Consider that employment agreements should also cover the same things. And if you filed a patent without a complete listing of inventors, that could cause issues for you down the road, and it might be better to be slightly over-inclusive than under-inclusive if all inventors are under the obligation to assign their rights to the company. Consider that hostile inventors might come up and not cooperate in the execution of the necessary agreements, and your employment agreements should consider that, and one strategy to do that is to have a power of attorney. I've seen a power of attorney baked into the employment agreement suggesting if they are unwilling or unable to execute any documents, that with this execution of the present document, they would grant power of attorney on of the corporation to act on the inventor's behalf. So those are some general pointers. Again, not legal advice, but we are here to help. Anyone member of the Founders Legal Intellectual Property team will be happy to assist in answering some of these questions. Thank you.